All right. Thank you for joining us today, everybody. My name is Michelle Morris, and I am from Consolidated Planning Group. We have a fantastic webinar for you today with attorney Rachel Dickison. She's going to be helping us talk about wills, special needs trusts, and guardianship. Before we get going, I do want to let everybody know. First of all, thank you for being here. All of the participants and all of the panelists today, I really appreciate it. We love hosting these webinars for you because one of our main goals as a company is to share educational, important information and to help educate you and advocate for you. So this webinar is being recorded. After today's session, you will receive an email with the link to the recording and hopefully the slides as well. If you don't receive that email, of course, you can always just check our YouTube channel. That's where all the webinars go. We cannot see you or hear you, but I do know you're out there and you can put any questions or comments into the chat box. That would be really helpful. We'll keep an eye on that chat box, but we're going to try to save those questions for the end. So if we don't get to your question, please be patient with us. Rachel will either incorporate what you're asking into her talk, or we'll get to you at the end. Or if you have a question that you maybe don't want to share with the whole group, you can reach out to either, well, any of us. We've all put our contact information in the chat box, and I will repost that, but you can reach out to us later. Again, we can't see you or hear you, so feel free to enjoy your lunch. And we'll get going. So again, I'm Michelle Morris. Consolidated Planning Group is a holistic financial planning firm. We are an independent firm, so that gives us the flexibility to be able to focus on serving special needs families. So about 90 something percent of our clients have an individual in their life who has some sort of disability, whether it be intellectual or developmental. And we truly focus on serving this community. We educate ourselves through the various community resources that we have. We are also members of the Special Needs Planning Academy. We are National Social Security Advisors, and I am a chartered special needs consultant through the American College of Financial Services. Now, we're based just outside of Houston, but we serve families all across the country, mainly in Texas for now, but all across the United States. So many of the things that we're going to be talking about today, because they're legal, are going to be based on Texas information. So if you are not from Texas, again, feel free to reach out to us and we can help hook you up with an attorney that is in your state who can advise you better. We have over 30 years of experience in helping families with financial things like life insurance and investments and securities, in addition to the special needs planning services that we offer. So families come to us for things like protection plans, lifetime care planning, transition planning, ABLE accounts, and understanding how to have your money in the right buckets so that you can save money for your children without jeopardizing those fantastic state and federal benefits. And like I said, we're here to advocate for you and to educate you. There are over 263,000 financial advisors across the United States. But out of those 263,000, fewer than 200 financial planning firms focus on helping families with special needs. So that is what we do. You're definitely in the right place. And it's less than 1/10% of all the financial advisors in the United States who focus on special needs planning. So we always advise that you start planning as soon as possible. We know it keeps you up at night, probably thinking about who's going to care for your loved one when you can't do it anymore. Well, the way to get better sleep is to go ahead and start making those plans as soon as possible. Now is the right time, no matter how old your child is. Think about what's going to happen after high school. There are educational options, vocational options, residential options. And very, very importantly, we say this on every single webinar because we believe so strongly. You should not just assume that a sibling is going to be able or willing to take over care for your individual with a disability. It can cause a lot of conflict and drama in your family. We've been working with families, especially that are coming to us now, and we have a sibling situation, and they're saying, Mom and Dad didn't plan. They didn't leave money for me to take care of my sibling. They kind of just dropped this all into my lap, and I don't know what to do. And they're feeling kind of upset about that when that happens. And on the other side of this relationship between a sibling and an individual with a disability, sometimes that individual thinks, all this time, this has been my sister or my brother, my sibling. We're good friends. We're partners in crime. We have a great time together. And now they're trying to step into a role where they're in charge of me, like mom and dad. You're not my mom. You're not my dad. And it gives them a sense of resentment towards their sibling. So you just want to be very, very careful about naming a sibling as a future caregiver. So again, we will send this recording to you, a link to our YouTube channel where this video will be. And put your questions and comments in the chat box. And I am going to turn things over now to Ashley, who's going to talk about a little bit about herself and her organization. And thank you again for being here. Thank you, Ashley.
Thanks, Michelle. Appreciate it. So I'm Ashley Hart. I am with LifePath Systems, and I am an eligibility specialist. We are the first point of contact for anyone looking for IDD services, intellectual and developmental disabilities. LifePath, you may have or hear us referred to as the LIDA for Collin County, Local Intellectual and Developmental Disabilities Authority. Each county has a LIDA, and that is where your services start. So LifePath is for Collin County, and then the other counties in Texas will have a LIDA. Our mission at LifePath Systems mission is to serve individuals and families impacted by behavioral health, intellectual, or developmental challenges, resulting in stronger communities. So what I'm going to do is kind of briefly hit on what our IDD division does. And then if you have any questions later on, or my contact information is in the chat as well, I believe.
Yes, and I've just reposted it in the chat as you were speaking to make sure
Awesome. Thank
everyone
you.
can see
Thank
that.
you. Oh, I appreciate that. So we maintain the wait list for HCS, Home and Community-Based Services, and Texas Home Living Medicaid programs. These lists have extensive wait times, averaging right now about 17 years. And that is pretty much on the mark. When we do get some names, I double check with our enrollment staff just to kind of see if that's what the wait time is. And it's still averaging right at 17 years.
Well, that's better than what I've heard. So good.
Yeah, so so that's what seems to be the average right now. So we maintain those lists. We also have HCS and Texas Home Living Service Coordinators. So once an individual is enrolled, their name comes up enrolled in those programs. We have the service coordinators that oversee the process and that they're getting everything that they enrolled in, the funding for that and how that's allocated for each individual. They kind of oversee that. There's also work with Community First Choice, a Medicaid entitlement program where there is funding for someone to work with individuals on activities of daily living or activities related to living independently in the community. This is a Medicaid entitlement program, so there is not a waiting list. There is a process to go through eligibility that you meet the eligibility guidelines. And once you do that and you have Medicaid, again, it's an entitlement program, so you would have to have Medicaid for that one. We have general revenue service coordinators where there is funding for individuals for case management, service coordination, case management, respite, and day hab. It's not near the funding that you would get on the HCS and Texas Home Living, but there is something there, especially that respite and day hab are pretty useful. LifePath also has a supported employment. We are a provider through Texas Workforce Commission, where we have job coaches that can help with interviewing, and then going onto the job site to help individuals be successful on that job site with the goal of easing out eventually. And then where there is a crisis services here through IDD, where we have a team of 2 right now that where there can be emergency respite, and they can work with individuals in a crisis to get services expedited or see what we can do to help that. So that was kind of a really quick overview, IDD in a nutshell. Said my contact is in there. I don't know if there's if we want to take questions or
Ashley, I just
how do
want
we
to
want
make
to do
sure that
this?
everybody knows what counties you serve specifically, because
Yes.
Florida goes by what county you live in.
Mhm.
So which ones do you serve?
Yes, we just serve Collin County. So that's where whatever county you live in, that's you start with their LIDA. I also have a list of all the LIDAs in the state. So if you want to reach out, I think my email and phone number, direct line are in the chat box. So I'll be more than happy to get you in touch with your LIDA.
Perfect. Thank you so much, Ashley.
You are welcome. Thanks for having us.
And who would you like to introduce next?
Oh, me?
Yeah,
I'm
you said you wanted to.
I believe that is for Life Path, unless Rachel, did you have anything you wanted to add?
No.
Nope. All right. Then I think it's Rachel Dickison now from
Yeah.
Weeks Law Firm.
Yay.
Wonderful. Well, it's so wonderful to speak with all of you. I have a lot of information that I have on the slides. I'm not going to cover everything that's on the slides, but I highly encourage you to look at the recording because there's going to be things that I'm not going to talk about, but it's important information. So if you could go to the next slide, please. Thank you. So we're going to be talking first about estate planning, special needs trust. I'm going to give you an overview of government benefits first. And then I'm going to switch over for the second half to talk about guardianship and your questions with that. I should be able to take questions for all of those at the very end. So I'm planning for that, but I'll try and integrate all your questions in at the same time as well. All right, so let's talk about estate planning. So estate planning generally is about what you want to do with your property after you pass away. So how we control, we protect your property, and how we decide who you give it to, and also how you give it to them. Next slide, please. This is really important for special needs families because we want to make sure that we're maximizing government benefits for your child. So there's additional planning steps that we need to take on top of the typical estate planning steps. And I know some of the questions that we had before were talking about why is it hard to find a special needs planning attorney? Part of that is because there's not a lot of us that specialize and do this every single day. So that's why it can be hard to find people. I promise there are people out there that can help you. All right, next slide, please. So generally, when we're talking about estate planning, I'm talking about having a will, having a special needs trust in place, designating who's going to be the guardian, not only for yourself, but also for your child, and then setting up your beneficiary designations to make sure your accounts go how you'd like them to go as well, and then coordinating with all of your other family members as well. The plan works really well if it's set up for you, but we want to make sure we're accounting for other people that may be interfering by trying to leave gifts to your child. We want that to be possible and not disqualify them from government benefits. Next slide, please. So I'm going to give you a brief overview about government benefits. There are excellent webinars that are available on CPG's website page that talk way more about particular government benefits programs, but I want you to know the overview of all of this. So the main one that you know, and you've probably heard of, is SSI, or Supplemental Security Income. Right now for this year, it's $967 per month for food and shelter, and that's the maximum amount you can receive per month. You also probably have heard of Medicaid or Medicaid waiver programs. They all have slightly different eligibility requirements, and you receive different things based on them. So Medicaid waiver programs, they're fantastic. You can get a lot of resources and care for it. But as mentioned before, there's a 17-year wait list for a lot of these programs. So one of the things I want you to know, if you're taking anything out of the program today, contact your local disability office and talk to them about getting on that wait list. If you're not going to take any other step, that's something really important to do. Next slide, please. So for SSI and Medicaid, generally the eligibility requirements, you have to be disabled and you have to have low income and limited resources. Generally, this looks like less than $2,000 in resources and less than $2,000 in monthly income. There's different requirements based on what waiver program you're on, so you'll have to look into that specific program. That gives you an idea. Next slide, please. So for monthly income, for SSI, it depends on if that individual is working, and they have a little bit of a different requirement. So this year, that's $1,620 per month, and then it's less than $2,000 for Medicaid. Now, income is food and shelter, cash, or any asset that can be converted to food and shelter. Now, that rule has changed in the last little bit, and I think I'll be getting to that in the next slide. But generally, that's what we're meaning when we talk about income. The other thing that you need to be aware of, if your child is under the age of 18, your income is considered to be your child's income. So a lot of times you wait until 18 to apply for your child because your income that you're receiving is counting against them until they reach 18. And then for Medicaid, if you're receiving just $1 of SSI, you will also be eligible for Medicaid. Next slide, please. All right, so in-kind support and maintenance is considered to be income. So this has changed the last 6 months or so. It used to be that it was if someone else, meaning parents or any other individual, is providing food or shelter for that individual, then it counts against them. There's a 1/3 reduction in their overall SSI amount per month. As of, it's supposed to be September 30th of last year, but it changed to only be shelter. So if someone else is providing any shelter costs for them, there's a 1/3 reduction in SSI. There are ways around this. One of those is paying rent, using an ABLE account, or paying their share of the rental amount. If that's something that you're concerned about, you want to increase your SSI, I strongly encourage that you talk to someone that does special needs planning so we can make sure that we're getting up to that main amount. Right. Now for resources, this is where special needs trusts come into play. So for less than $2,000 in countable assets, there is a difference. So what's not counted is your home, a car, and this is in the name of that individual. So a home, car, personal item, or 529 education accounts. But things that are counted against them are bank accounts and uniform transfer to minor accounts, which is usually what you have whenever a child's under 18. It starts counting against them whenever they turn 21. So any asset that's in their name, it's going to count against them. Next slide, please.
I just want to add that includes a life insurance policy that has a cash value to it. So if you have a life insurance policy on your child, you want to check on that.
All right. Now, there is another program that you may be eligible for if a parent passes away or if they start taking their own Social Security retirement. That child may be eligible for disabled adult child, which is a benefit that they can receive if they were disabled prior to age 22. They can receive up to half of their parent's Social Security check, and then they can potentially receive Medicare. But if you're concerned about this, if this situation applies for you, you should be able to talk to Social Security or to a special needs planner about how that impacts your plan. Next slide. All right, now Medicaid waiver programs. We mentioned these before. The important thing is get your child on the list as soon as possible and figure out what the best program is for you, because it may work for some individuals, but it may not work for your child. So it's great to talk to a LITA so that you can know what that looks like. Next slide, please. And then 2 programs that are not needs-based, which means they're not based on these income requirements that I talked about, are SSDI and Medicare. So there's other programs, they're a little bit different. They're different than what I'm talking about today. Next slide, please. So a common question I get is, do I truly need to be on government benefits? I recommend yes. We want to make sure your child is getting eligible for government benefits. Excuse me. Even if you think that you may not need that extra income or that ability, it provides for a lot of flexibility in your overall estate plan. And really, it can help your child so that they have a better long-term care plan for the future. So it may not be something that you think you need now, but planning for the future is always a good option. We want to keep that option open for you. Next slide, please. All right, so a special needs trust. What happens with a special needs trust is typically government benefits are insufficient. That $967 per month, it's not enough for your special needs child. So we want to make sure that they have additional funds and that they can be taken care of after something happens to you. Next slide, please. So how we do that is we create a special needs trust. So a special needs trust, if it's properly drafted and the trustee is knowledgeable on the rules and can correctly distribute all of those assets for them, a special needs trust will not be an accountable resource. So any money that you leave to your child in this special needs trust does not count against them for that $2,000 limit. The result of this is that they can be eligible for government benefits. And the overall goal of this trust is not to replace government benefits, but to provide for additional care on top of what the government already provides. Next slide, please. And then additionally, and it's not just that they are not resources for that individual, it's also not considered to be income. So they will not have any issues with achieving government benefits and being able to have them. Next slide, please. Thank you. All right, so a special needs trust, or just a trust in general, most people hear the term trust, they don't know what that means. Really what it is, it's a legal document. It lays out who are the people that are going to manage the money for your child with disabilities. And then how do we get the money in that trust? And then who spends it? How does that work? And the overall goal of this is to create a safety net for your child. So we want to make sure all of that is put into place. It's really just a document that gives direct guidelines on how we do that and what things you consider to be appropriate for coming out of the trust. Next slide. Thank you. So benefits are also not the only reason we do special needs trusts. If you think that your child may not apply for government benefits, or even if they are on government benefits now, but they might not need to be in the future, there's not a harm in having a special needs trust because it will operate as a typical trust if they're not on government benefits. The one exception to it being a regular trust is they cannot be their own trustee. So distributions can be made for their health, education, maintenance, and support, and it provides protection for them, but they can't be their own trustee. So that's just something to keep in mind, even if you think that they may not be on government benefits. Next slide, please. Now, I know that there were some questions about this. So there are 2 different types of special needs trusts. One is a first party, the other one is called a third party. So it depends on whose money it was that's used to create the trust. So the first one, first party special needs trust, it's created with that individual with a disability, their own money. Now that can come from a variety of different sources. Most commonly, it's whenever they receive an inheritance, but they don't receive it, they receive it outright. They don't receive it into a special needs trust. When a parent didn't do any special needs planning, it goes into a first party trust. Then we have child support. Child support in Texas, I have a slide about this later, but it must go into a first party trust. And then also savings of their own. So say that they worked for a while and they have to put all of that into a trust that doesn't disqualify them, that would be another reason. The other thing that's not mentioned here, and I know we had a question about this before the webinar, was for military benefits. So if your going to have a survivor's benefit plan and you want that to go to a special needs child, it's actually required that it goes into a first party trust, not into a third party. So that's just something to be aware of. You need to talk to an attorney about how that impacts your plan, because it's a little bit different than our typical special needs planning. With a first party trust, there is a Medicaid payback provision. What this means is there is a listing of every dollar that Texas Medicaid, or whatever your state is, their Medicaid program, what they have spent on your child. They will not come to collect that money until after the child has passed away. But any money that's left over in a first party trust, because it was their money, Texas Medicaid will come back. They will want payback for anything that they've used or spent for that child before they give it to the other individuals. Now, this is different than a third-party trust. So let's go to the next slide and talk about third-party trusts. This is probably what you've heard of when you hear special needs trust. When someone tells you you need a special needs trust, this is what they're talking about. This is created with someone else's own money. Typically, it's parents or grandparents want to leave an inheritance to that individual with disabilities. And so they create a trust for them and they leave money in their estate to that individual with disabilities. The wonderful thing about a third-party trust, it's created with someone else's own money. There is no Medicaid payback provision. So the person that's setting up this trust, they get to decide after that child with disability passes away, who is the beneficiary. It can go to the other siblings, to other grandchildren, whoever you want it to go to. It does not have that Medicaid payback. All right, next slide, please. All right, now another common question I get is how do we actually get money into the special needs trusts? The most common way is that we have the will says it goes into the special needs trust. We also have that you can set up your beneficiary designations, either on your life insurance policies or your retirement accounts, and those can be left to a special needs trust. Now, I will mention that you don't want it to go into that individual in their just their name. You want it to go to their trust specifically. And retirement accounts are a little bit complex. I don't have enough time to talk about how that's a little bit different, but it does look a little bit different with retirement accounts. So you want to talk to a special needs planner about that. It can also be a gift or it can be child support. Let's talk about child support and how that's a little bit different in the next slide. So child support after age 18, child support can count against that child as income. So you might not be aware, but in Texas, child support can be ordered for the entire lifetime of that disabled beneficiary. So after age 18, it counts against them as income. So it's going to disqualify them from government benefits. If they have more than the amount of government benefits, so say right now it's 967. If they have 970, they will completely lose SSI and Medicaid. Even if they have less, it will still reduce the amount of SSI that they are receiving. So in order to avoid a loss of these benefits, the divorce decree itself must order that child support is paid into a first party special needs trust. So you have to have not only a first party trust, but also work with the family law attorney to put that into the decree. So it's a little bit more complex, and it's something that I always talk about because most people don't know that this does occur and that might happen. All right, next slide, please.
And if you don't mind, just to, there are so many questions and comments coming in through the chat box. Hopefully you're going to hear a lot of the answers as we go through this presentation. But if not, I encourage all of you to set up free consultations with Consolidated Planning Group or with Rachel. Rachel, you also offer a free consultation?
We typically do paid consultations, but we can take it on a case by case.
Okay. Well, we do offer a free consultation and we'll give you information about how to set that up later. So please do remember that you can reach out to us after this webinar if we don't get your questions answered.
All right, now our last topic about special needs trust, and I'll try and get to all the questions that are in there after I finish up. I just need to get to guardianship. So for special needs trust, what happens if you do not have the special needs trust? So either the child will not have an inheritance, they will inherit outright, which means it needs to go into a first party trust. There's a Medicaid payback, or they will leave assets to a family member that's not that individual. Often in that circumstance, that will result in that individual just having SSI and Medicaid. So it is not a good option. You really should set up a special needs trust that goes directly to that child and used for the benefit of that child. I strongly discourage any of these options. It's not a good idea because you can't guarantee that that money is going to be spent on your special needs child. All right. Now I know we still have some questions. I will try and get to them, but we need to talk about guardianship.
We
So-
do. Absolutely. It's very, very important.
Yes. So guardianship. As we all know, whenever you turn 18, you have certain legal rights and responsibilities because you turn 18. You can sign a contract, you can get a lease. There's a lot more different things that you can do out in the world. Under age 18, parents handle doctor's visits, they handle money, they handle all of the different things that are needed for your care. But that responsibility is left to the child whenever they turn 18. Now, that works in most cases because most children are able to handle that responsibility. However, some young adults are vulnerable to predators, and we're concerned that someone's going to try and take advantage of them. And that's where guardianship comes in. Next slide, please. So what if that young adult with disabilities is not able to make the decisions needed to take care of themselves? They can't manage their own finances. They can't manage their medical care. They really need help and assistance in evaluating what these decisions are they have to make, or they're just not able to make those decisions whatsoever. They need someone to make those decisions for them. That's where guardianship or even alternatives to guardianship come in. So let's talk about guardianship in that process. Guardianship is a legal court-created relationship between the ward and the guardian. So most often, I'm going to use parent and child because that's our most common case. Most of the time, the person with disabilities is the child, and they're called the ward or proposed ward. Then you also have the person that gives help, frequently a parent, sometimes a sibling, that is the guardian. So the court decides if the proposed ward is unable to manage their own personal, financial, medical affairs. And if they make that determination, then they will appoint a guardian, sometimes co-guardians, to manage those things for the proposed ward. And it also takes away the civil rights of that proposed ward. It's a very serious process because they're not able to make those decisions. Someone else is making them for them. And we're really looking at all of the daily decisions and things that they have to do. And this is what we call substituted decision making. The guardian makes the decision, the proposed ward does not. Let's go to the next slide. So there is a shift in public policy that's been happening in the last 10 probably years, longer. It's been longer than that, but there's a growing legal trend away from guardianship. So especially in Texas, there is a movement to more adults should retain their civil rights and not have to go through guardianship. So the effect on the guardianship process itself is it's more stringent. There's more requirements for the adults that are going through that are trying to become the guardian. And we have other wonderful opportunities for those young adults with disabilities on other things if they don't really need a full guardianship. And then an example of how this is impacted, guardianship is no longer assumed if someone's in special education. They may need a guardianship, they might need a less restrictive alternative. So let's talk about what those are. Oh, we'll talk about that in just a second. So the two types of guardianships, there is guardian of the person and guardianship of the estate. Most of the time with young adults with disabilities, we're talking about guardian of the person, not the estate. So guardian of the person is whenever the guardian makes decisions about the medical and living arrangement decisions, all the day-to-day activities of that proposed ward. It does require some annual reporting to the court. And then guardian of the estate is whenever that individual has assets, they have money, they can handle the property and finances of that person. There is additional reporting requirements beyond just a simple report whenever you have a guardian of the estate. So remember that the court creates the relationship, so they have to monitor it and make sure you're doing your job as guardian. Next slide, please. All right, now there are different types of guardianship as well. It dives in a little bit deeper. So I mentioned civil rights of that individual. A total guardianship is whenever they retain no civil rights. They don't retain any ability to do things. With a partial guardianship, this is becoming more and more common. This is whenever they retain the right to do certain things. The most commonly retained rights are the right to vote, to drive, to marry, or determine their personal residence. Now, it can be one of those things. It can be all four. It's really a combination is fine. It's still going to be called a partial guardianship. And then you may also hear the term temporary guardianship. This is when an immediate action is needed to take care of that individual, and it's for a very limited amount of time. So it is likely you're not going to encounter temporary guardianship, but I do want you to be aware of the term. All right, next slide, please. So with guardianship, it can be severe. So it can be a lot. A lot of people wanted alternatives, different things that could be done if guardianship is too much for them. So the goal of less restrictive alternatives is to allow that person to be as independent and self-reliant as possible. So for guardian of the person, this is day-to-day management decisions of that individual. Alternatives for that is creating a medical power of attorney for that adult with special needs. So they make their own medical decisions, but they have someone as a backup that's able to help them making those medical decisions if they're not able to. We also pair that typically with a HIPAA authorization so that that person can access their medical information. We also have a durable power of attorney or a financial power of attorney. So this allows the person to be able to access bank accounts, to sign contracts, handle any financial matters for that individual. That does not require incapacity on the behalf of the individual with disabilities. It can happen where the individual can make those decisions, but the supporter or the person that would typically be the guardian can also make those decisions. I'm going to talk a little bit more about supported decision-making agreement in the next slide, so we'll get there. But let's talk about guardian of the estate. So guardianship of the estate, the most common one, and this is why a lot of young adults with disabilities, they don't need a guardianship of the estate. They have a representative payee for their Social Security check. So frequently, the only money that's going into that account for that individual is their SSI check. If that's the case, they can have someone that is designated to receive those assets and spend them for them. That's called a representative payee. And it's different than the power of attorney agent because Social Security they don't recognize powers of attorney. They only recognize you have a representative payee that does that for you. Now you can also have a special needs trust. So any assets that are inherited, large amount of assets that are managed for their care, it's not in their name, and the trustee is the one that manages those. So that's why we don't need guardian of the estate in that case. We can also have a joint checking account. So you can have an account with that individual so you can both monitor what's going on there. So we have a lot of different options. Sometimes this doesn't work for young adults with disabilities and they really do need a guardianship, but sometimes this can be a good alternative that we can do. Next slide, please. All right, so there's also supported decision-making, and this is the most frequently used. I've seen it a lot for guardian of the person. So Texas was the first to enact supported decision-making. You'll also hear them referred to as SDMAs, but there's a list of all the different states if you're in a different state than Texas. The person with disabilities, I'm going to call them the decider. Then the person that is helping them is called the supporter. So the decider makes all of the decisions, everything that they want to have happen, but the supporter is the one that helps them gather up all the information, understand their options, pros and cons, risks and benefits, and helps them making decisions. So they get to decide The decider gets to decide where they live, what supports and services they need, where they want to work, but the supporter is there to communicate that to other people and to make sure that they know what needs to happen, really helping them make that decision. We all have a person in our lives that we go to for advice. This is just putting it down in a formal agreement. So the form, there's a state form. Disability Rights Texas has a great form online that you can fill out for these if you want to have those. And then it has to be signed and notarized by the person with disabilities and the supporter. So let's go to the next slide, please. So the advantages of this, it's got a lot of independence. It really helps so that the civil rights are not curtailed. It's about supporting that individual, not controlling them. The disadvantages is there's no court supervision. So if you're worried about a risk of this person being exploited, that is not going to fix that issue. There's still a potential for conflict between the supporter and the decider, and there's still a risk of abuse. So we can't fully protect them against that, unfortunately. There also is some issues with getting people to honor this agreement. As much as the education efforts have been out there to try and teach people about this, that's been enacted for 10 years as of this year. We still have issues with people not recognizing what that is. So we want to make sure that you're comfortable educating people about this if you have a supported decision-making agreement.
But supported decision-making, it's not really a legally binding document. Is that right? More of a gentleman's agreement?
So based on my understanding, in the actual statutes itself, there is a way to enforce it, but in practice, it's not enforced. And there's not an easy way to enforce it in the way that, you can do a lawsuit to force someone to do it. It's not as easy as that. And so it turns out being more of a gentleman's agreement. But that's my understanding is I think there's the legal ability to do that, but in practice, you have problems with it. And then the last thing I wanted to mention on less restrictive alternatives. In Texas, now that we have this enacted, it is okay to try those first and then go to guardianship. In fact, one of the requirements of guardianship is we have to see, do we have any of these options? Would any of these potentially work? If they don't work, okay, we're going to do guardianship. If they don't, if they haven't worked before, it's a great reason to get guardianship. But we have to determine that those do not work first before we do guardianship. So that's another layer that your attorney is going to be talking to you about. Now, let's assume that you've been appointed guardian. What are your roles and responsibilities? So guardian of the person, they're ensuring that the ward's needs are met. They're going to be looking at their medical decision making, where they live, where they work, their education, and also who has access to the proposed ward. So they really control a lot of the day-to-day life of that individual. Now, with guardian of the estate, they handle and invest the ward's money. So this is, again, if they have money in their names, not if it's in a trust. That's the trustee that manages that. But the guardian of the estate manages the money for the ward's care, pays for their bills. They can also sell property with court's approval. They can enter into contracts. There's a lot of different things they can do, but it's less frequent with our young adults with disabilities. Next slide, please. Now, there are limitations on guardianship. There's a lot of things that guardians can do. There's a lot of things that guardians cannot do. The big things are they cannot place a ward in a mental facility. That is a separate proceeding. It's not a guardianship proceeding. It's a mental health proceeding. So that's going to be a different type of proceeding. Guardianship doesn't fix that issue, unfortunately. A guardian can also not force medication that proposed ward or that ward does not want to take. They do not have to take responsibility for any illegal actions of the ward. That's the ward's responsibility under the law. But it also doesn't protect the ward from making bad decisions. So you cannot fully protect them from that. You can say they don't have the ability to sign a contract, but they still can't prevent them from signing the contract in practice. So that you can maybe help them get out of it, but they can still sign a contract if they wanted to. Now, you also do not have to use your own assets to pay for the ward's debts. So that's another concern that I have families talk to me about that they're concerned about. So it's really helpful in a lot of contexts. However, it doesn't solve some problems that parents encounter. Next slide, please. All right. And the most common question that I get is guardianship appropriate for my child? So I want you to consider these options. I'm going to have a longer list, I believe, in the next slide of specific situations. If you're on the fence, you're trying to decide between guardianship and less restrictive alternatives, think about these questions. If you're still on the fence, talk to an attorney about it. So, is guardianship truly necessary to care for and protect that individual? Can they make decisions that are in their own best interest? Can they provide for their own food and shelter? And are they vulnerable to being taken advantage of? And that's the overall things that we're always looking at. In the next slide, I'm going to highlight a couple, there's a list of a bunch of different situations. The big thing I ask a lot of my clients is, we're talking about medical care. Would they be able to tell you that they have a cut and seek medical care for that? Would they be able to understand what's going on with that? Okay, they can understand that, but can they understand they have a surgery, they need to have a surgery in the hospital? Do they understand what the doctor's saying? Can they make that decision on their own or without support? Or even with that support, would they understand that? That's where we're looking at those big decisions. It also applies to financial accounts. So there's a long list here, but that's just something to keep in mind. Depending on your child, every individual is different. So we all look at a different calculus for all of these different individuals. Next slide, please. All right, and then we also want to see, are there any alternatives? And have I done everything to make sure that they still have the independence and the decision-making that they can have before we go to guardianship? All right, now I think that's my end of my slides for guardianship. Okay, so I'll get there and yeah. So for, we can go ahead and go to the next slide, sorry. So for when you need to take action on these things. A special needs trust, it's not related to guardianship, although I do have a lot of families around age 18 that are doing both. But creating a special needs trust, you need to have a plan in place before you become disabled or before your death. So a lot of times we can't control, we don't know when that's going to happen. So what I say is, whenever you're ready to have these conversations, it can be difficult to have these conversations and think about that. Once you're ready to have that conversation, it's worth talking about it. Also, special needs planning, I mentioned before, there's not a lot of us. It can be expensive. One of the things that you should consider doing is saving up some money before you do all this planning. That might be something that you need to do. And I recommend that go ahead and save up that money and know we're planning for all of this. We're going to set it in place for the future. Make sure you do it right the first time. Find someone that is truly knowledgeable about this and does this frequently so that you only have to do it once. And then for guardianship, you want to start 6 months before the 18th birthday. If they're after age 18, then you can do it at any time. But the first date that we're legally allowed to file is 6 months before the 18th birthday, and the hearing cannot occur for guardianship until after the 18th birthday. All right, I think that's my last. Okay, so the result of all of this planning overall, really the goal of everything is we want to make sure that you have peace of mind. We want to make sure that there's a financial plan in place. You have the people, you have the individuals, you have instructions for the care. We're making sure that we retain the eligibility for government benefits. But overall, we want to make sure that you have a good peace of mind about all of this. You're not worried about it. And we want to make sure that your child has a good life after you, that we make sure that we're able to keep that. And there are ways to do that. And there's only so much we can plan for, but we can plan for a lot. So let's go ahead and get that planning done and we can make sure. Okay.
And we always say at Consolidated Planning Group that we plan for the worst so that if the worst happens, you have a plan in place and you're going to be okay. But we stay positive and hopeful and optimistic that the best is going to happen. And then you just have extra, extra money to make your dreams come true. So.
Definitely. Then the last thing I will say, so currently right now, we're located in Plano. Currently, we're taking cases for guardianship in Collin and Denton. We may be taking cases for Dallas in the future. We have in the past. We're just with all the cases we have right now, we're not taking them right now. For special needs trust and other special needs planning, we practice all over the state of Texas. So if you're in Texas, we can help you. If not, we can refer you to another attorney, or like Michelle mentioned, they have a list of people that they can help with. So then you talk to an attorney with that. Okay.
Yes, and here is all of Rachel's contact info so that you can reach out to her directly if you have questions. Now, if you are looking for someone in Houston or in another state, we can certainly help you find somebody who can help you. So don't worry about that. I am going to, I do have a couple of quick slides here, but you'll receive these and you can look at them later. Mainly, I want to let you know that Consolidated Planning Group does offer a free consultation, and you can go ahead and use the QR code to sign up, or you can call or email me. I've been putting my information in the chat box, or you can call or email the office. I would appreciate it if you would let me schedule your appointment so I can get credit for it, but that's fine. Either way, it's a completely free Zoom consultation, usually about 30 to 45 minutes, to make sure that we answer your questions, we learn about you and your family, and then we can have some time to talk to you about what we do and what we charge for our financial planning services and how that process works and what it looks like. So please don't hesitate to reach out to me directly. Now, in terms of all the questions that we've been getting in the chat box, I'm going to try to go through some of those, Rachel, and put you on the spot if you're ready.
Yes, sounds good.
Okay. So the special needs trust, is that typically set up as revocable and then converts to irrevocable?
Yes. So typically, whenever we're doing it for estate planning, it's revocable and we're planning that you can make any changes that you want to do. However, if it's a first party, we usually set it up as irrevocable because of the laws. So most of the time it's revocable, but a lot of the times it's irrevocable based on your situation.
Fantastic. There's a question about ABLE accounts. Should you get an ABLE account through Texas, or is another state better? Now, we set up ABLE accounts for our clients, and for our clients and for our own families, we do not use the Texas ABLE. We use an ABLE out of Virginia. But we have had webinars about ABLE accounts and answered a lot of questions about those in the past. So feel free to check those out as well, Sarah. Can you only put money into a trust, Rachel?
No, you can put all different types of assets. So one of the, you can put cash, you can put real estate. A lot of my clients will leave their home to the special needs trust so that their child has a place to live. Can be investment accounts, really it can be any type of asset that you think of. Now I will say for other types of trusts, specifically, I didn't talk about this at all, but if you do an ARC trust that they also set up special needs trust, they have limitations on what type of assets you do. But if you're doing a private special needs trust, like I was talking about, that you should be able to put whatever you want to.
Yes. And those funds can be invested. We can help you with that. We can make sure it's going to grow, but stay safe at the same time. Have hopefully some nice rewards, but with a lower risk profile. So if they've set up a trust for a 4-year-old, you don't want to set up guardianship until you can't set up guardianship until they're 18. But if you have that trust set up for a child, as they get older, how often do you need to change it and have it updated and that kind of thing?
So it really depends. Our advice to our clients is to look at them every 3 to 5 years. The reason why is it's not necessarily because of the child and their age, although I would say that's part of it. A lot of it is legal changes. So we won't know if there's any major changes to special needs trust law, and we recommend that you come in every 3 to 5 years. Just make sure that it's exactly how you want it to be. The same thing, we recommend that to all of our clients though, because the people that you might have wanted to be taking care of your child 5 years ago may not be the people you want today. So that's why we say 3 to 5 years, but it can be longer. The big thing is if you change your house, if you are moving states, if you're doing things like that, you want to have your documents revised, especially if it's for another state, to make sure that it fits this state's law in whatever Medicaid program that you're going to be with. So that's my general advice. I know that's not a clear answer, but I would say every 3 to 5 years.
Yeah, so much of our answers have to be, it depends. It depends on your specific circumstances. So can you put any of the individual's own money in the third party trust, or you have to keep it separate, completely separate with a first and a third party?
You have to keep it separate. And honestly, it's really important because we want to make sure that there's no mixing of funds. Because I don't know exactly what would happen if you put a first party funds into the third party, but they could consider it that now it's Medicaid can go after all of the third party funds. I don't know for sure if that's what they would consider, but we don't want to take that risk. So we want to make sure that it's truly separated out.
Okay, fantastic. How do you go about getting child support beyond age 18? Well, that's, a question for your divorce attorney. Hopefully you can find one who knows a little bit about special needs planning, but in the state of Texas, you certainly can get child support beyond age 18 if you have a child with a disability. And in that situation, it needs to go into a first party special needs trust. SSI, you do not need an attorney to help you file SSI benefits. Sometimes you might run into issues, but generally we can help walk you through the process. You do have to do it yourself because it's a government entity, but we can help you understand that. Okay, so if they have if the beneficiary dies and Medicaid can come back and claim reimbursement through the trust. What if the child never used Medicaid or Medicare? Can you have a different beneficiary? And then also, in addition to that, how do you know how much money Medicaid has spent or Medicare has spent on your child?
Great question. So for if they never use Medicaid, they never use Medicare, although Medicare, I believe, does not have doesn't have a payback. So it's mostly for Medicaid. But on the trust document, you're going to list out who you want to be the beneficiary. So most of the time, it's usually how we default structure it is it goes to the special needs child if they have any children, goes to them, and then it goes to their siblings or to their parents, whoever their heirs are at law. But you get to choose that whenever you set up the trust. As far as knowing how much Medicaid has spent in office, you have to contact the local, it's not local, but the Texas uh, HHSC, I believe that the program that administers Medicaid. I've lost the name for right now, but they keep a track of how much that is, and then whenever the person passes away, we have to contact that office to get a listing of whatever that looks like. It's not necessarily that all of the trust funds have to go that way. They do some negotiation, but I would plan for if whenever that child passes away, it goes to Medicaid. It doesn't go to your other beneficiaries unless there's some other extenuating circumstance.
I'm trying to make sure I get as many of these as I can. You can have a special needs trust even if they don't qualify for other benefits. Like you said, if it doesn't need to be special needs, it will just revert. So that's okay. Separate trust first and third. We put our contact information. We can help you find local people all throughout Texas, all throughout the country. We've got resources for that. Everyone's saying thank you. You will get a copy of the presentation. The link to the recording and the slides will be emailed to you, whatever email address that you registered for this webinar. LIDA stands for Local Intellectual and Developmental Disability Authority. And that would be things like Bluebonnet, ACOG, Tri-County, MHMR, Texana, Harris Center, those are some of them. The difference between an ABLE account in Texas compared to in another state, there's a website where you can go in and check different kinds of ABLE accounts and compare them. Just Google a state ABLE account comparison or something like that. But if you want us to open it for you, we use the one in Virginia. If we put our home in the special needs trust and then we move, can it be changed to a new address even though that trust is irrevocable?
So it depends. So if I typically would recommend that the special needs trust is not in that situation, it's revocable. You don't have an irrevocable trust. However, the home is not usually put into the trust until after both parents or both people pass away. It's only put into the trust after it's distributed overall. So if they put their home in that situation, say that it is a home in the special needs trust, you move and it's in the trust, you cannot move it out of the trust. The special needs trust would be the one buying and purchasing a home. So the proceeds from the sales of the home would go in that trust, and then you could use it to purchase another home. But in a typical situation where you're leaving your home and to your child before you pass away, we don't do that transfer until after you pass away.
Okay, so I have one more question that I'm going to answer, and then one more question for you to answer, and then we're going to have to be done because we're already past 1 o'clock. Can I set up the special needs trust and guardianship as a single parent? Yes, you do not have to have a spouse to have a trust or guardianship. And then for you, Rachel, can a third party non-special needs trust, just a normal trust, be reformatted to add the special needs provisions to it?
Yes, it can be. Sometimes, depends on the attorney. Sometimes it's not worth going through all that trouble, and we want to just create a new special needs trust. But yes, you can reform whatever the provisions are as long as it's revocable. You can do that. If it's irrevocable, we might have to go to court to fix it, but there is a way.
There's a way, it just adds money. All right. Thank you, everybody, so much for joining us today. Again, please feel free to contact Consolidated Planning Group or Rachel Dickison. We can certainly help you with your needs, anything related to special needs planning, whether it be on the legal side or the financial side. We can certainly help you. And we are so glad that you spent this hour and 2 minutes with us. And I hope I get to talk to you soon. Thank you, everybody. Thank you, Rachel and Rachel, for being here, and have a great rest of your week. Thank you so much, everybody. Bye-bye.